topic that has actually been one of our core focuses as a firm, and something that a lot of people in the ecosystem have been talking about, and there's a lot of uncertainty about. So, once again, like all the other panels that we had today, we don't have the answers for you. We'll brainstorm. We'll hopefully have a good discussion, help share kind of the diverse opinions that we have represented up here. But if you're expecting absolute clarity, I'm sorry. So today, what we really want to talk about is the tokenized securities, and specifically the regulatory aspect when it comes to token offerings, or how regulators might see token offerings, and what the compliance environment might look like in the future. So just to start it off, if you guys want to introduce yourselves briefly and talk about your experience in the crypto space.
Go ahead.
Sure. David Sachs. I'm a investor now, general partner of Craft Ventures, and I'm also the founding chairman of Harbor, which is focused on the tokenization of traditional asset securities.
Ryan Selkis, founder of Messari. Hello again. For those that weren't here in the morning session, Messari is an open source data library that's basically building an editor database for crypto assets.
Hi everyone, I'm Katie Haun, and I'm not chewing candy, I'm chewing a cough drop because I'm kind of a bit hoarse. Relevant, I think, to this panel is I'm a former federal prosecutor. I was the Justice Department's first crypto coordinator. I was asked in 2012 by my superiors at the Justice Department to help shut down and prosecute Bitcoin, which we can all laugh about now. Instead, what I did is I prosecuted some of the earliest criminal use cases involving cryptocurrencies. And last year, I joined the board of directors of Coinbase. I also teach cryptocurrencies. I taught at Stanford Law School. I now teach at Stanford Business School. Pleased to be here. Thanks.
Of course. Thanks, everyone, for joining us. So kind of to set some context for the audience, do you want to talk about kind of what the current regulatory environment is like? And obviously, there's uncertainty around some aspects, but what are the main questions that people in crypto are asking from regulators that maybe they haven't gotten answers from yet?
I think from my perspective, one of the biggest questions I'm hearing about this year is, how do we tell the difference between a security token and a utility token? And where is that dividing line? And is there a test for that? Do the networks have to be live already? Does there have to be a protocol that's actually you can have a consumptive use for? I think those are the questions I'm hearing.
And a derivative of that is, are we just going to fall into the same trap and same venture capital cycle where retail investors and consumers of these protocols get the last access and the last money in? Or are we going to find a framework that allows early participants in these networks to actually participate in the upside given their contributions?
Yeah. So, I think we're all kind of familiar with the Howey test, which is the best that we have. Do you think that, or if you want to talk about what the Howey test is, but then also the real question here is, do you think that there is an alternative test that should be proposed? Are there any weaknesses to the Howey test that don't necessarily make sense in crypto?
Well, yeah, the Howey test is obviously from the 1940s, so it doesn't have a ton of application to crypto today. That said, it's the kind of last word from the Supreme Court. We have had a number of regulatory pronouncements since the Howey case came down, and there have been a number of lower court rulings, just none that have been from the Supreme Court. I think one interesting phenomenon I'm also seeing is people in this space right now, we're in 2018 and in 2017, because of all of the mainstream interest that came about, people are really focused on the SEC, because of course we heard a lot from the SEC in 2017 and also with the phenomenon of ICOs. If you had been in the space in 2013, you would have been talking a lot more about what does FinCEN think? What does OFAC think? FinCEN, of course, is an arm of the Treasury, and they were one of the first, if not actually the first government agency to promulgate guidance on virtual currencies. So I think one of the interesting things is we shouldn't forget about some of these other agencies that are very much still out there and still looking at the space, haven't lately been as active or making as many pronouncements, but very much still have a finger kind of in things.
We're all regulatory nerds up here. How many people know what the Howey test is? Oh, Pretty decent chunk. Okay, so for the handful that don't, it's an investment in a common enterprise. So it's the first two prongs, with the expectation of profits based on the work of and efforts of others. And so the real issue in the industry right now is that even though you can make an argument that most, or at least some of these protocols and these networks are truly geared towards the consumers of those networks, and the tokens are to be used for consumptive purposes, the way that they've been packaged and sold and speculated on pretty much puts a black mark on just about all of them, especially those that did a public offering and then immediately listed them on exchanges and flipped them, and it just gets exacerbated by the whole dynamic of giving preferential treatment and access to funds who then had maybe 90 days to get liquid at maybe a 5 or 10x markup. That's a recipe for disaster in terms of getting the SEC to focus all of its energy. So I think as we talk about the Howey test and as we talk about securitization of these tokens or utility tokens that are basically going to be marked as securities, the question now is not, did these look like securities? Did we try to pull a fast one on the SEC? But I think it's really how we get out of it. And I know that's certainly what we're working on from a transparency and self-regulatory standpoint, and also David is trying to do a little bit more in terms of embedding logic into the code of these assets to bring them into compliance.
Yeah, I mean, so there's two kind of separate related things. One is the tokenization of traditional securities, which is actually like what motivated Harbor, is we wanted to put traditional assets like real estate or fine art, things like that, on a blockchain. And then there's the securitization of tokens, like utility tokens, which is this question about do these tokens that are used in a software protocol get regulated like securities? And I think the ecosystem clearly wishes that wouldn't happen. But the SEC lately has certainly made some really strong definitive statements that these things are securities. And so the question is, so I think there's two ways it can go. One is like you stop doing ICOs. The other is you start regulating or you start applying securities laws to ICOs. And we published a blog post. Me and Josh Steins, the CEO of Harbor, on proposing what we call the PICO, or private ICO, where you would ICO but only to accredited investors, and then after 90 days you could trade those tokens to other accredited investors under what's called Section 487, and then 9 months after that you could actually freely trade them to the public under Rule 144. And so it's not like an ideal situation in the sense that a protocol wouldn't get immediate, like perfect liquidity for its token, but it would provide like a compromise middle ground. So we'll see. No one's really like kind of bitten on that framework yet, and that's not really our focus. I mean, we're really focused on again things like real estate, but we kind of threw it out there to see if people would view it as a solution. The other piece of this is that if utility tokens are now securities, that means that all these exchanges, which allow trading of them, like that means that they're effectively unlicensed securities exchanges, and that brings up a whole host of issues, both for the centralized exchanges and then also for the decentralized exchanges. So that's like I think probably the next domino to fall here, is that unless we figure out like a way to get protocol tokens back in the utility, not securities bucket, then I think it's going to be like a big problem for these exchanges. So yeah, anyway. Yeah.
So David, one question that I've had about Rule 144. So you basically got this 12-month holding period, and Rule 144 should be able to give public market investors or retail investors access to these assets. Is that something that some of the current crypto exchanges could take advantage of? Or because traditionally this would be done through something like OTC markets with the public securities. How do you guys think about that, and is that a strategy for some of the exchanges?
So I think you'd still have the problem that these exchanges have to be licensed to, make a market in securities. So we're kind of assuming that's going to happen somehow. Like the SEC is going to start granting ATS licenses, and however it happens, whether it's OTC or through licensed exchanges, I think that over the next year you're going to see a bunch of properly licensed exchanges or broker-dealers spring up to solve that problem. So yeah, I agree with you that you have to have that in addition to kind of the compliance baked into the token that we've proposed with we created a standard called the R token standard, which allows you to essentially program some of these restrictions into the trading of tokens. So like for instance, you could say this token can only be traded to another accredited investor, and that would be like one way to keep them out of the hands of unaccrediteds and apply these securities laws.
So there was recently a comment made by Jay Clayton, who's the chairman of the SEC, where he talked about potentially seeing a path for tokens or assets in general to evolve away from being securities to being utilities. And he gave a really good example of like a laundry token.
Yep.
Where perhaps before the laundry machine or laundromat is ready, you can sell the laundry token ahead of time, and then later on when people are just using it to do laundry, like is it really a security anymore? And obviously these are big open questions, but what do you guys think about the potential for securities to evolve into utilities? And then also, as a follow-on question to that, how do you think the SEC might think about that? Because it obviously takes things out of their jurisdiction.
Well, I think it was a really important point that, really, he was walking back one of his earlier statements, which was that he had never seen an ICO that wasn't a security. So I think it represents a real shift in kind of how the SEC is thinking about it. And one of the things to keep in mind is how the SEC acts. David, you mentioned that no one's really bid on this yet, but the SEC doesn't come out and say, yes, we agree with you, or yes, we don't. They have formal mechanisms, right? They can do 21A reports. We saw that when they issued a report on the Dow. That's a formal mechanism by which the SEC can put out some guidance. The other thing they can do, of course, is they can take an enforcement action. I don't know how many people in this room are familiar with how that gets brought. How many are already? Okay, no one. So basically what happens is at the conclusion of an investigation that the SEC has done, they then go before the commissioners, and the commissioners have to vote whether to allow that action to go forward. If it's voted on that it can go forward, the SEC goes and files it in court. Importantly, this isn't a criminal case. This is a civil case. And so sometimes we're hearing, oh, these promoters of ICOs were arrested by the SEC. That's actually not the case. Really what you have there is you have the Justice Department and the SEC teaming up together. So you have a companion criminal and civil case. But one of the other ways that the SEC speaks is through no action letters. And basically an issuer, in this case of an ICO or of a token, could go write a very specific request to the SEC and get an answer as to whether or not the SEC would take action against that issuer. And those are called no action letters. Interestingly, we've seen in Switzerland, FINMA, which is the Swiss regulatory body, has said that they will start issuing no action letters for ICOs and token providers, but not where the network is already, not where the tokens have already been issued. It has to be on a prospective basis. So I think one thing that we need to keep in mind here is how we see the SEC speak. They speak through 21A reports, enforcement actions, no action letters.
Yeah, I think most of the language coming out of the SEC has been pretty predictable and relatively measured, because if you think about the letters and everything that they have put forth today, it's mostly been to scare people into compliance and try to mete out fraud just through the specter of a hammer that could come down at any moment. I thought the most interesting comments from Chairman Clayton were back in November, actually, and it was part of a longer discussion about how to mitigate bad actions in the public securities markets, whether you're talking about penny stocks or tokens or whole slew of other areas under the SEC's purview, and how can you do so that you can actually ward off enforcement actions and help the industry self-regulate itself. And one of the things that they brought up was improvements in transparency. And I think one of the core challenges in the token economy right now is that the insiders have access to all the information, and they're going to make all the money. And when the market corrects, that's going to end up very badly for the retail speculators that are actually trading these things on exchanges. So, the perspective that we took is, all right, this is a really tough problem. This is an asset class that knows no jurisdictions, is traded globally. People are already taking advantage of regulatory arbitrage. What are the SEC's mandates? It's to protect consumers, ensure fair and efficient markets, and facilitate capital formation. The last category is not a problem in this market right now. So you have to think about what can help improve the fairness and efficiency of these markets and actually protect the non-hedge funds and non-investors that are in this room. And I think you can get a long way the way towards where the SEC wants to get if you just adopt some common sense transparency measures at the token project issuer level. Things like, what is our supply? How do we distribute it over time? Do we disclose insider transactions? Is there a predictable secondary sale policy that we have in place in terms of how we measure our treasury tokens? Things like that, you're talking about things that are on the front page of a 10K or an S1 in the public securities market. So, I mean, this is like remedial stuff. And if we can start there and agree on very non-controversial common standards, it's not the whole answer, but I think it's at least one component to a really difficult problem so that you can start to separate the truly fraudulent projects from the ones that are trying to be above board and trying to engage and trying to do the right thing, even if it's not a set of straightforward answers immediately, given how fast this ecosystem's evolving.
I think that's exactly right, Ryan. I mean, because obviously the resources of the SEC are somewhat limited. They have about 4,000 personnel on their staff. And we already know there are well over 1,000 ICOs that are out there. And so I think just to your point, Ryan, the SEC can look at, have you even thought about governance questions? And have you tried to make any good faith efforts to comply? If so, those are not going to be the best vehicles to bring their first set of enforcement actions. I always make this point. It's true whether you're talking about the Justice Department, whether you're talking about some of the Treasury agencies like FinCEN or OFAC, or whether you're talking about the SEC. These are kind of novel cases of first impression. The SEC does not want to bring a set of cases that they cannot win in court. And so they need to really focus on what are the best vehicles. If push comes to shove, and the ICO issuer is not going to settle, is not going to agree to cease and desist, and is going to challenge that in court, is this a case that the SEC can win? Is it a dead bang winner is always what we used to say. And those are the ones that the government and that these entities want to bring, especially in the first, I mean, I know that they've already brought a handful of actions. Most of them involved pure fraud. But the first few that they bring in this space, they're going to want to have a deterrent effect. And they're going to want those to be really good vehicles where people can look and say, yeah, none of the things that Ryan just mentioned were at all taken into account. In fact, they were willfully blind to those factors.
Okay. So you mentioned, Ryan, that one of the mandates for the SEC is capital formation, promoting capital formation. So with tokenization, we get the opportunity for a whole new class of financial products, whole new ideas, like just two kind of like simple ones that I thought of are like, if I can prove that I've owned shares in a REIT for some period of time, like maybe I get a discount on my rent for buildings owned by that REIT, or I get a discount on an iPhone if I've owned Apple shares for a certain number of like shares times years, right? Like these types of cool financial products, these new things can really promote capital formation or creating new assets, new asset classes. Like, how do you think specifically the US regulatory bodies look at new asset classes? Is it this giant fight for jurisdiction and everyone's going to try and claim like, no, this belongs under our jurisdiction? Do you think that we need a separate regulator? Like, how do we actually promote capital formation with these new, just like brand new assets?
I mean, that sounds good and really aspirational, and it sounds really good if you send a caravan of lawyers and VCs to educate the SEC and showcase all these examples, right? And I'm sure that's the pitch that's been made. The problem is that's just not the case today, and it's not even close. So capital formation is, and I mean, I'm not in the SEC obviously, but I cannot imagine that it's even a blip on the screen right now because you're not actually allocating capital towards these new innovative projects in that way. It's 100% speculation driven today. And I think that's the concern, right? So the overarching concern will always be skewed towards protecting retail investors with the thought that this is a bubble that is unsustainable. And later on, as we actually develop standards, it's not the SEC, right? That's going to have to be some type of legislative action to actually define this as a new category. And I think if the industry can coalesce around some best practices now, you've got a hell of a lot better shot at influencing how that new legislation is created, both here in the U.S. and then abroad as well.
So, can I take a shot at that? So I actually think security tokens are going to be like huge starting this year. I think starting this summer, you're going to start seeing some pretty meaningful security token offerings. I mean, I think we're going to be doing some. I think there's other people. The first one will be the hardest. Second one gets a little bit easier. Third one gets easier, and then I think it's just a flood. This is on the security token side. It's not. I don't think the legal and regulatory questions around utility tokens are going to get resolved anytime soon. But the nice thing about security tokens is their legal status is not unclear. Like, they're securities. Like, we concede that. We will apply all of the correct rules. And what's taking so long is just building the software to do that. But I think by this summer, whether it's us or other people, I think that all the infrastructure will be in place that you can actually legally enforce all of the correct rules on a traditional asset. So take like something like a REIT. You start with the fact that let's say you're talking about private REIT shares. You've got basic securities rules like only selling to accredited investors. You've got to do KYC, and anti-money laundering on them. OFAC check, all that stuff. That's the basics. And then you've got to enforce the REIT rules. So you've got to make sure there's over 100 shareholders, and 5 of them can't own more than half of it, and so forth. But all that stuff can be enforced programmatically. So I think it's all coming, and the reason why is because when you put assets on a blockchain, you make them more liquid, more transparent, and you plug them into an ecosystem, and there's tremendous value in that. There's something like, depending on who you ask, there's something like $7 trillion of private real estate, commercial real estate, not like residential, in the US. And the discount on the valuation of a private asset compared to a public one is at least 20%. So just right there, you could unlock $1.4 trillion of value if you're able to move all of that private real estate into a sort of a more liquid state on a blockchain. And so I think this is going to be like a massive opportunity. I think it's like, it might even be like the main use case for blockchains is this kind of digital ownership. So yeah, I'm pretty excited about it.
And that should be something that regulators welcome. I mean, this ability to curb fraud, waste, and abuse and increase transparency should be a story that the community is telling to the regulators and policymakers. I mean, I think that a lot of people at FinCEN or OFAC would be really happy to learn more about what Harbor's doing for these very reasons. I mean, it also has compliance in mind.
Yeah, so our CEO is a lawyer and former prosecutor as well. And so, we have started having a lot of these conversations with regulators, and I think the reaction's generally been pretty positive because we're not going there proposing to do something that's in a gray area or like, trying to convince them to change the way they regulate something or trying to convince them that something is not a security when it might well be. Our approach is we're just going there saying, hey, well, we're going to enforce all of the securities rules on this asset type. We're just putting it on a blockchain. And there's already been, there's been, I think, enough, there's already, I think, a growing amount of support for that. I think Delaware has an interesting initiative to allow shares of stock to be put on a blockchain. So yeah, I think it's going to be generally well received by regulators, and long term, I think it allows them to regulate these markets more efficiently because there is more transparency. I mean, right now, like ownership of private securities is all analog. It literally exists in file cabinets, like on a piece of paper. Once you make it digital and it lives on a blockchain, you can actually see what's happening. And I think there'll be like, I think one of the follow-on effects here will be you'll start getting really interesting analytics companies or actually, you know, able to provide insight into like what's happening in these markets, because now you can actually see trades happening in real time. So yeah, I think it's a really interesting frontier.
I completely agree with you, and actually I want to reference another quote from one of the regulatory agencies where Chairman Giancarlo of the CFTC was testifying to the Senate. This was actually back in January, but this really stuck with me because he's testifying to the Senate and he starts talking about what blockchain could have done to help prevent the financial crisis in 2008. And he mentions, you know, perhaps this can be such an effective tool for regulators because we can actually model out what the financial connections between these various entities are, and we can have a real-time model of like, well, what happens if you remove Lehman, right? And perhaps that can enable some more targeted regulatory intervention in order to promote stable markets, as opposed to kind of the much less targeted approaches that they had to resort to. So I completely agree with you. I think that, you know, as these regulators really start to understand this technology, specifically for securities that are obviously securities, you know, and they see this technology as a way to upgrade the system, then you know, they should be very friendly to it, and it seems like they are. You know, they're coming around. But the question that like keeps on coming back, and I think that a lot of people in this room are going to be really interested in, is, you know, not only on the upgrade to the financial system that's provided by tokenizing existing securities, but should we be trying to fit all of these ICOs and all of this new asset class into the security framework kind of willingly, because there are these interesting avenues, and you know, perhaps that's a path of least friction to actually succeed? Or is this somewhere where, you know, despite the regulators being somewhat friendly and understanding the technology, it's worth it for the community to fight and actually try and cause political change in order to support this new technology? And we've seen that happen before. I mean, I live in Austin. Like we banned Uber for 2 years for some silly regulatory reason. People hated it, and now we have Uber again.
Well, I mean, to be clear, like if the community wasn't using utility tokens to fundraise, there wouldn't be a regulatory issue. I mean, the regulatory issue comes from the fact that, you know, the community wants to fundraise with the issuance of these tokens as if they were, you know, shares of stock or like a safe note or like a SAFT, which is, you know, basically as a security. But then they magically want them to become, you know, utility tokens, you know, once a protocol is live. And that was the distinction made in the SAFT framework, where, you know, the idea was that pre-functionality, they'd be, you'd sell them only to accrediteds through SAFT notes, they'd be securities, but then the second you launch the protocol, now they become utilities and are totally unregulated. And, you know, what the SEC has said is like, no, sorry, we don't buy into that. And I mean, I think the recent statement that at some point they can become, you know, utilities is like, I think that's actually a good sign, because I really do think that at some point they do start looking more like, you know, tokens that, you know, make a protocol function as opposed to a fundraising tool. But to be clear, like the reason why this issue came about is because people are fundraising with these things. If the community stops fundraising with them, you can launch protocols and not be regulated.
Well, it is the one killer app for blockchain that we already understand.
Exactly,
so
exactly.
I don't think it's going to stop.
Yeah, no, and I'm not advocating that it should. I'm not advocating that it should. I think there are, I mean, I think even within the current framework though, like again, if we followed like the PICO format, you could totally still do private ICOs. And I mean, now look, the public, for better or for worse, would not be able to participate for a year. So, you know, if your job is to protect the public from potential scams, you would think that's a good thing. If your job is to give them access to these investments, that's a bad thing, but that's basically what you'd have to forego. And
or you sell equity in the issuing company, you reserve a little bit, and then you sell at the launch of your protocol, right? I mean, there's ways around this. I agree with you 100% though. I think, you know, Bitcoin's revolutionary. Trying to do an ICO and like shake your fist at the SEC, you're not starting from like a position of principle. Uber and Airbnb, like their battles were the taxi cartel's bullshit. This is a better, faster, cheaper service. Airbnb, same thing. We're helping people supplement their income, and we're helping make sharing rooms more affordable. Bitcoin was, we're going to give access to uncensorable, unseizable stores of wealth for people that are in economies that the governments just destroy and debase the currency. ICOs do not fall into that bucket. ICOs today are generally cash grabs. And I think the better teams are starting to come around and think a lot more carefully about how they structure them. But I mean, you get laughed out of the room with anybody with half a brain if you try to make the case that this is like really about like freedom and technology. It's just that's a bunch of crap.
Right, and atmospherically, it doesn't help that certain very large projects have said, well, fine, we'll move offshore. We're going to do this in, name your jurisdiction. And clearly, they're still marketing to U.S. persons, and they're not going to have a good case that they weren't. So it just doesn't pass the laugh test. I think one important thing also to note is you mentioned new legislation, Tushar, and Ryan, you just mentioned Airbnb. One of the other kind of bodies we're forgetting in our system is the courts. And we're talking about regulatory agencies, right, in the independent and the executive branch. We're talking about legislation, so from Congress. But the third branch is really important here, I think, and that's courts. Think about it, we're talking about the Howey test, the Supreme Court. What are courts going to say are the right ways to think about these things? I think some of those earliest cases are going to be really important to answering that. And there's no outreach that's being done to courts, partially because you can't do outreach to courts. One of the interesting things I think we'll see develop, we saw this in the money service, like money service and business and transmitter licenses play out, which is that sometimes the courts that are getting these challenges first are state courts or their lower courts. It's not going to the federal court, it's not going to the Supreme Court first. And so you get a mix of decisions. So I think that's going to be something very interesting to watch too. And maybe, I don't know that anyone wants to take on the SEC, but maybe filing a case in a particular jurisdiction, in a particular court, if you feel like you have a really good case. That is one way that we can also get answers, not just through legislation. Of course, you have to be prepared that you might lose.
Well, the other thing with taking on the SEC, if you actually want to take on the SEC, I think what the approach industry-wide should be is, here are all of your bad options. You don't really have any good options because this is a new technology, it's complicated, you've got all these jurisdictional issues, you want cases that you can win. Here's maybe a way that you can work with industry to help guide some of the self-regulatory organizations that are starting to sprout up and some of the more serious teams that are starting to set standards. That at least gives them an out that says, okay, we're helping these projects come into compliance with the spirit of existing securities laws, and it's going to make it 10 times easier for us to find the cases that we can win because we know all the good projects are going to fall in line with this framework. It's not perfect, but it's an iterative step in the right direction. And I think that's the approach that in very different ways I think all three of us on the stage are taking between Coinbase and Harbor and Messari.
Awesome. Well, wanted to open it up for audience questions at this time.
Katie, I think this one's for you. So you mentioned the courts. Are there any, can you give us an example, if there is an example, of a current case that it makes a good candidate to go to the Supreme Court?
No.
And if there isn't a good case now, can you speculate on sort of what sorts of cases would likely in the future go to the Supreme Court?
Well, I mean, first of all, you can't just pick your case to go to the Supreme Court, right? How the Supreme Court works, at least at a federal level, is you have to grant what's called certiorari, right? So the Supreme Court has to choose you. And so there's really I actually clerked on the Supreme Court back in my old days as a lawyer. So I have some insight on how this happens. And what happens is the Supreme Court waits for what they call a circuit split. That is a split amongst many different federal courts of appeal before they'll take a case, right? Because the Supreme Court's job is to resolve confusion that affects many cases, not just one. And so they'll wait for, say, the 7th Circuit, the 9th Circuit, the 4th Circuit, the 1st Circuit to all disagree, and then they'll take one of those. So I think that's years off. And sorry if I suggested that the industry should be trying to get something before the Supreme Court. That's not what I meant to suggest. Because again, the Supreme Court would have to itself choose to resolve that. And that's a process that would take, right now, 5 years. for a case to get to the Supreme Court because it has to go through the lower court systems. And in terms of what a good case now would be to bring, I can't think of one because right now I haven't seen an enforcement action that I think has been unreasonable. So I'll say that. If and when there's an enforcement action that's totally unreasonable, and the SEC chose, and I don't think they'll do this, by the way, to make an example of a case and say it was security when it's clearly a utility token. Like, let's think of our best case for a utility token. Perhaps that would be a good vehicle. I don't see that happening.
Well, it could be the issue or the challenges, the enforcement action, right?
True.
I mean, that seems like the more likely path.
Or an exchange.
Yeah.
Well, I mean, I think the case would be against the issuer. Another choke point, I think, are some of these exchanges, I think, are going to have some problems. The ones that were offering all kinds of tokens for the reason that David said, because then you're dealing in unlicensed and unregistered securities.
Could you share more detail on how you see utility tokens existing in the future? And then also, if you think the way Ethereum did things was fine?
That first one is really broad. So how do we see utility tokens existing
in the regulatory environment?
Mm-hmm.
So the conversation between what defines utility versus security and what that's going to mean for startups 6 to 12 months from now.
I guess I'll start. I mean, I think there is no such thing as a utility token, right? There is such a thing as currencies and commodities. There is such a thing as securities. So I think the closest thing that we have to a precedent in terms of a regulatory body talking about what a utility token could look like is FINMA, the Swiss regulator. And I don't know how much has really been defined there, if there's any standards that have been set. It's more just a taxonomy that they've come out with. So I think that's the path that we're heading down. But for there to be an actual regulatory framework around utility tokens, you would need an act of Congress. The SEC or Congress would need to basically bless either the CFTC or SEC or Consumer Financial Protection Bureau with new powers to regulate these. And that's just going to take quite a long time.
Yeah, I don't think FINMA has opined. They've just set forth guidelines about these three categories, and they've invited, and I know there are some pending requests at FINMA for no action letters, but none that we've seen come out yet.
We're going to know very soon about Ethereum because I think they're meeting about it on Monday. So
we're going to get some new information very soon.
I wouldn't say that it's going to be very soon, but that's just, I don't think just because we know there's a meeting about it that they'll.
There's not going to be white smoke that comes out of it.
Right.
I would just add that if you're a startup in the U.S. and you're fundraising by selling tokens to the public, you're insane.
Right now.
Right now. That is definitely a no-no. I mean, I think if you're selling tokens to accredited investors that you are doing KYC on, I think that's a different story. I think that's okay.
Yep, but I would add to that to be very careful because I've also seen with the Reg D offerings to private placements that they say, we're not doing general solicitation, but actually that's exactly what they're doing, or they're not promising secondary value or secondary possibilities to trade. But then if you look in some of their promotional materials or if you look into some of their emails, in fact, that's exactly what they're doing. And you can bet that the SEC or other regulatory bodies or enforcement bodies are going to be able to get a hold of those emails and contents. And in fact, we've seen at least 80 subpoenas go out for information gathering for that very purpose. So I think if you are going to do a private placement and raise money in the United States from accredited investors, you better be darn sure that you're actually following the spirit of the law and not, turning a blind eye to the fact that you're just going to take their word for it. They're an accredited investor, for example.
Yeah, thank you for adding that. I'm not giving anyone legal advice here.
Me neither.
People try to do these creative things now too to get around this. I see all the time where it's they're like, oh well, we're only doing a private sale and following all the established exemptions, but then we're going to airdrop a ton of tokens and help create liquidity. And so I think that fits perfectly with what you're saying. There's going to be a spirit of the law test in terms of will the regulators actually come after you, where there is no regulation around airdrops because it's just like an inconceivable thing.
The closest thing to airdrops that the SEC actually has considered, though, in the form of, as I alluded to earlier, no action letters, back in the 90s, giveaways, stock giveaways for like some beer company, I think it was, in the 90s, and was free stock giveaway okay, or was that, did that fall under their jurisdiction, and was that okay? Was that a security? And through a no action letter, they suggested that it was.
Oh.
Now that's from the 1990s, and it also involved the purchase of some of the company's products in conjunction with the stock giveaway, so I think you could distinguish where it's a pure airdrop here and there's no money that's changing hands or nothing required of the person receiving the airdrop tokens. But that's actually also an open question. I think some of the other interesting things we're seeing are people are trying to do Reg A plus offerings. And there, the SEC has a definitive amount of time, I believe 90 days, to get back to the, people proposing to issue under a Reg A plus. And I've been told, I don't know if this is correct, but I've been told that there are a number of crypto ICO projects that have filed for Reg A plus offerings with the SEC, and the SEC is literally sitting on them, that they are not acting on them within the proposed regulatory or statutory timeframe.
The spirit of the law test is also a little bit of a moving target, right? Because yes, the market's corrected a little bit in recent months, but as a whole, most people are not underwater that have gotten into the industry. And I do think that's an important point, because if there is a bloodbath in the markets and a lot of people start losing money and you start seeing like the 60-minute specials and all that, then the issuers that issued steep discounts to professional funds and paid exchanges for listing and all that, now their target just got a whole lot bigger right on their forehead.
And not just, and also by the likes of the FTC, the CFPB, and I could go on, and the state regulatory agencies and the state AGs. But one thing we haven't talked about is the plaintiffs' bar. And let's make no mistake, the regulators are kind of out there creating some uncertainty, but you've got private right of action for plaintiffs in class action lawsuits under the securities laws as well. I think that's an issue that really hasn't been talked about much in the community.
So I think we have time for one more question.
Hi. So recently we've seen some companies file Reg D paperwork. I saw 0x recently filed some Reg D paperwork. What do you feel? So companies can't retroactively file Reg D offering if they sold to non-accredited investors, correct?
Is that a question for me?
Well, I'm not a lawyer.
Well, I'm not giving legal advice up here, but I don't think that's correct. I mean, I think if you're in the situation and you did something, I would encourage those issuers to talk to a lawyer about the best ways they could look to either unwind or ameliorate, mitigate some of what they've done. But no, I don't think that it's, ex post, you could go file a Reg D offering.
I guess the better question is, how do you think the SEC will handle retroactive non-compliance?
You mean retroactive compliance?
Non-compliance.
Will they go after people who took these actions back in early 2017 or 2016, before there was all this attention, before they knew that it was wrong?
I think this goes to my...
Before they knew it was wrong.
I think this goes to my
or
point
again,
about...
wrong is the wrong word, but you guys know what I mean. Sorry.
No, I think it goes to the point about looking for the best vehicles. Again, SEC does not want to be in a position of going before a court or before a jury and not being able to win that case. So I think they're going to pick very obvious cases.
Yeah, I mean, I would just also add that there were a lot of projects that did ICOs before, so the SEC started really giving strong guidance on this like in Q4 last year, and prior to that, I don't believe that every ICO is like presumptively like fraudulent or something. There are like plenty of good projects who went. And a lot of them actually, I think most consult with lawyers. Remember, like the SAF framework was proposed by a law firm. And the legal advice to clients was that, again, it established this pre and post functionality distinction where if you're raising money prior to being functional, that was a security and you could meet your requirements by doing it as a SAF note, like same type of requirements as safe note. But then post functionality, it would have a consumptive use, and you'd no longer be a security. And so like lots of people follow that advice. I don't think like those people were trying to like break the law,
Right.
And so I don't know what the SEC is going to do about it, but I think now there are definitely a lot of projects out there that are just pure cash grabs and scams, and like hopefully those are the ones that get cracked down on. But look, I think there's like plenty of people who fell into this trap for like legitimate reasons. Now, I think the situation today is different, which is why I think if you're still doing it, you fall into my bucket of being insane. But the people who did it like a year and a half, 2 years ago, no, I don't think so.
Yeah, and I think they'll look also to the number, like the amount raised. I think they're going to have some factors, right? They're going to look to how much was raised. I mean, did you raise, $2 million or did you raise $200 million? Did people lose money in your project? What was your team like? Who were you? What representations were you making? They're going to look to a lot of factors, I think, like that also. And timing.
There's another really interesting practical issue here, which is if all of the projects were forced to unwind, let's just use kind of the edge case hypothetical, you'd probably have a situation where you had 500 different little instances of Mark Karpellis and the Mt. Gox bankruptcy where they return capital in dollars, but then they've got these massive balance sheets, and all of a sudden they've basically walked away with tens of millions or hundreds of millions of dollars just in the appreciation of the other tokens that they have in their treasury. So, at today's prices, it creates this really, weird dynamic where if you're not only that, but like the investors in most of the projects today, I'd say, don't want their money back. Like, I don't want my money, I want my tokens, right? Filecoin's a good example, right? And that's one of the only ones that I actually invested in. I believe in that project, right? I believe in the team. I think they have best intentions. I want my Filecoins. I don't want my cash back that I invested in the SAF. So that challenge is, I think that's a challenge because for the most part, the issuers that are doing things above board are much more popular than the SEC. And that's not the end all and be all, but it is, I think, a factor.
Awesome. Well, thank you for joining us for the panel today. Thank you, everyone.